Hello, folks. This is Eric Sinrod with your Tech Law 10, where the law and technology intersect. I'm with Dwayne Morris in San Francisco. As always, I'm joined with my colleague across the pond, Jonathan Armstrong. Well, I'm sure he'll introduce himself in a second. But as always, well, not as always, but a lot of the time lately, we're thinking about AI, artificial intelligence, pros, cons. What's on your mind today, Jonathan?
Thanks, Eric. And yeah, I'm Jonathan Armstrong at Punter, Southall Law. Well, I've been thinking quite a bit about agentic AI, and I know that's sort of the trendy thing in AI circles at the moment, but I think it has some legal implications that perhaps people aren't talking about as much. So I thought it would be useful at least to have some initial thoughts on that. So for those who haven't yet caught it, agentic AI is, if you like, AI that can autonomously go and do things. So, for example, you could hire an AI agent as a project manager, and that AI agent can go off and hire other AI agents to do other things. So it might hire one bot to do translations, for example. It might hire somebody else to hire other agents. And it might create a cluster of agents, almost like virtual employees working for you to get a project done. And the benefits of that are claimed to be the ability to scale much quicker and do projects to a much more aggressive timeline. And a lot of big tech corporations have been investing quite a bit in this. I went to a demo last week, for example, from a big tech corporation that claimed that it could do a project from sort of soup to nuts in less than 24 hours, including the hiring of various agents to play to their specialties. But I think it does create legal issues that we need to think through. And I've got a few that I think we need to consider. I mean, first of all, I think ordinarily, whenever we're procuring people or agents to do things, then we go through some sort of due diligence process. And we look at things like data security, and we look at things like where the data is going. And if these autonomous agents are hiring in without us, then that obviously creates a risk. Now, obviously, you could program these agents to do the due diligence against your rules, but you need to think how you're going to do that. And you need to particularly think where the data is going to go. Now, obviously, a month or so ago, probably agents would have hired things like Deepseek resources because they were meant to be quicker and cheaper in some cases. But obviously, there are ramifications with Deepseek. It is likely that your data would be going to China. Do you want it there? There may be potential sanctions issues in future. And of course, DeepSeek has been banned by the grantor for use in Italy, and that might have an impact if you've got Italian data that you're trying to process or analyze. Next, I think there are transparency obligations. And as we've said before, transparency is the sort of the most favored weapon in GDPR regulators' armory. Maybe north of 70% of GDPR cases touch on transparency or lack of transparency. And it's obviously very hard to be transparent about the AI that's being used when you don't know yourself if the agents have gone and hired other agents on your behalf. So unless you've got a proper trail that enables you to build transparency into everything you do, that means that you might breach your obligations under GDPR. And there are obviously more obligations coming under legislation like the EU AI Act. I think another area that's potentially difficult is in decision making. Now, we've had a new ECJ, new European Court ruling on the 27th of February that puts this into the spotlight, if you like. The case concerns Dun& Bradstreet in Austria that was using some sort of technology We don't yet know whether it was AI because that's not yet been disclosed, but some sort of technology to risk individuals when applying for credit. And the individual concerned said, well, this seems to have been done by an automated process, and I don't seem to have been able to get information on how this decision was reached. And the ECJ have said, well, that's part of GDPR. Dun & Bradstreet will have to give you meaningful information about the logic involved in decision making. And again, if you're not controlling that, if the bots are controlling that on your behalf, how do you meet your obligations to give meaningful information? And by the way, that's often an area of conflict in AI because an AI developer might say, oh, that's in our black box or that's our secret source. Well, what the ECJ decision seems to be saying is what we've said on these podcasts before, that you can't just say that. At best, you can raise it with the courts will consider that, but there's no gimme for the fact that this is a new technology or protected technology. Obviously, we've talked already about the EU AI Act. There's a potential implication here, particularly because some systems have been prohibited since last month. So that could be another issue that you hit when you're using agentic AI. There are potential issues around disclosures and patents. So if what you're processing is something that you intend to patent, you could potentially lose patentable status in simple terms because different bots know about what's going on. There could potentially be SEC or listing rules requirements as well that mean that you should keep the data tight. You could possibly, in some circumstances, waive privilege as well by putting that data into an agentic system if it was privileged data when it went in there. And then I think the final thing to say is that just because you're using agentic AI doesn't mean to say that existing laws don't apply. So we've already talked about things like sanctions. There's a potential things like IP infringement. There's all sorts of strange rules on procuring different things. As I say, some of it's sanctions related, some of it export control, some of it outright prohibitions. And then also there's a worry about bias and discrimination, I think. So even if a decision is made by a bot for you, you're likely to still be responsible for that decision. So again, you'll want to know the logic that's being used and reassure yourself that it isn't discriminatory in any way. So what are the solutions? Well, I've got 3 quick solutions before I hand it over to you to maybe add another 10 more, Eric. First of all, I think you've got to understand the tech, what's being used on your behalf, how are those decisions being made. Secondly, I've talked about it already, look at rule setting. So what are the parameters of the bots? What are they authorized to do? What are they not authorized to do? How do you put guardrails into that system? And thirdly, consider a human in the loop. Now, I know that that slows things down. It might make decisions easier to justify from a GDPR point of view. And that might be a short-term measure whilst you get assurance that the system is working properly, but consider some sort of halfway house where you've still got humans verifying the decisions rather than letting the bots have free reign. So I know that's a bit of a long-winded look at some of the obligations, but what are your views, Eric?
Very concise, actually, and you hit on so many things that I was thinking of. But how dare you, sir, suggest that we have those clunky humans in the loop? But no, I mean, so many of the things you touched on, Deepseek, transparency, decision-making, patent, and IP issues are ones that I've considered as well. And you brought up discrimination. It's something you and I communicated about just earlier today. And by the way, you can see it's a beautiful day here in San Francisco. Actually, that picture was taken up a while ago. However, the weather is exactly that today. So not a bad place. Not a bad place to live as a human. But As we communicated, this was on the discrimination front, just 5 days ago in Colorado, the ACLU, our American Civil Liberties Union, filed a lawsuit on behalf of an indigenous and deaf woman. This complaint was filed with the Colorado Civil Rights Division and the EEOC, our Equal Employment Opportunity Commission, against a financial software company and a vendor of human resources assessment software using AI. And the core allegation was that this particular woman was denied a promotion on the basis of her disability and her race. And the complaint alleges specifically that the companies violated the Colorado Anti-Discrimination Act. Yes, states have such statutes. The Americans with Disabilities Act, which is federal statute. Title VII of the Civil Rights Act, also a federal statute, by using allegedly biased AI technology in hiring, resulting in potential systemic discrimination. And more specifically, the complaint sets forth and alleges that the employee was encouraged by her supervisor to apply for a seasonal manager position, but was forced to use the employer's third-party AI video interview platform, which features automated speech recognition systems to generate transcripts of applicants' spoken responses from video interviews. And ultimately, the complaint alleges that the deaf employee requested but did not receive an accommodation for the interview based on her status, and was later rejected for the position and subsequently received feedback telling this deaf employee to work on, quote, effective communication, close quote, to provide, quote, concise and direct answers, close quote, to adapt her, pardon the quotes, quote, communication style to different audiences, close quote, and finally, quote, to practice active listening, close quote. So perhaps getting to your third recommendation, getting a human in the loop here might have helped to the extent these allegations are true. And remember, these are allegations. They're not proven facts yet. The complaint was just filed. But maybe having a human in the loop would have intervened such that the interview process for this particular person, who specifically was deaf, could have interviewed in a way that was, fair and potentially not discriminatory as to her. So this is just sort of one consequence of having AI, assuming again this is true, potentially dominate in a certain area. But what are your thoughts about that specific context, Jonathan?
Yeah, I think it is a really interesting case. I mean, my daughter applied for a job where the only applications were taken by a similar AI system. She was in student housing at the time where the connection was unreliable, and she'd been told by peers that some of them had been rejected when their Wi-Fi was slow because the system perceived that as hesitancy and delay in providing answers. So I think there's discrimination not only in terms of the ability to hear, etc., but also issues around social mobility, etc., as well. If you can only afford a relatively slow internet connection, then can you get jobs in the modern economy? So we have to consider, I think, carefully some of the implications of using software like that. And obviously, not many employers seek to be discriminatory, but that could be the end result of the technology that you're using.
Yeah. And then speaking of Deepseek, I mean, that's catching on here. And there is an issue regarding, where's the data and where is it going? And do we want it to be in China, for example? That's a whole nother topic because it's growing in popularity here. It's deemed quite effective by the populace. It's cost effective, obviously. I think about transparency, I think that was your second point. As we say, sunshine is the greatest disinfectant, transparency, right? So,
Yeah.
but I don't want to run
Absolutely.
afoul of our time limits here. Are there any I don't have any greater recommendations than you have other than to supplement along the lines that you suggested initially.
Well, fabulous. So let's call it a day then. And maybe if people on our LinkedIn group have got other ideas that we should be adding to our wish list or worry list, then let's crowdsource some solutions as well, and we can add those to the LinkedIn discussion group as well.
But we can certainly say the AI train is out of the station and moving fast.
Yeah, absolutely. Yeah. So I guess we should wrap up.
Please.
I'm Jonathan.Armstrong at puntersouthall.law.
I'm Eric Sinrod at Wayne Morris. I'm in the San Francisco office. My email is ejsinrod@dwaynemorris.com.
And then we look forward to speaking to you again in a few weeks. And if anybody's got any topics that are burning issues for them, then do let us know and we'll do our best to accommodate. But all that remains is to thank you for watching or listening.
Thank you.